easier case from my reading of the probable cause affidavits. This would be State of Kansas versus Christina Rivera. It's an unfollowed criminal case, 23 MR 344. Announced appearances.
May it please the court, the state of Kansas appears through Assistant Ellis County Attorney Jim Rutherford. Ms. Christina Rivera also appears pro se and by Zoom. Ashton Taylor, the alleged victim in this case, is also on.
Okay. Mr. Taylor, I don't know where you're at. Is that you up? Am I? Yeah.
Yes.
Do you have any objection to the lifting of the no contact order?
I do not. Like, he's fine coming back.
So Mr. Clayton at the bottom has nothing to do with this case at all, but I was developing a story in my head as I was watching this where he hit his snooze on his alarm a couple times, woke up and went, oh shit, I have court. So he opens up his phone and just, is waking up while he's walking around waiting for his court hearing. Because that's the only thing I could come up with is he's not completely awake on why he's walking around without a shirt and smoking a cigarette. Right?
Mr. Rutherford, do you have any objection to lifting it?
No objection, Your Honor.
I don't either.
Okay.
All right. I reviewed the affidavit. I think Ms. Rivera saved Mr. Taylor potentially from some unfortunate potential consequences. So my reading of it is, but Ms. Taylor or Ms. Rivera, I want to mention to you that, and I want to explain this. Under Kansas law, a battery is any offensive touching done in a rude, insolent, or angry manner without the consent of the other party. And under the law, police officers have no discretion. In the old days, police officers on the street had a lot of discretion as to what they could do in these kinds of situations, but now they do not. If there's any evidence of a potential battery, which is offensive touching, it can be, I've described it, it's as simple as this. If you get in a political argument with somebody and you're angry with them and you poke them in the chest to make a point, you've committed a battery under Kansas law. It doesn't require a slugging or a hitting. So while you may have been doing a very good thing on behalf of Mr. Taylor, the officers presented with the evidence I saw in the affidavit really had no discretion but to make a custodial arrest. That's the way it works. All right?
Yeah, I didn't know that. That's why I was wondering.
We discussed this briefly in a past stream, but we didn't really dig into it. There are certain states that have mandatory arrest laws as it relates to domestic violence. So I thought maybe let's look it up. And the American Bar Association actually has a chart that lists each state and what the rules are. It's a couple years old, so I highly suggest you look up your individual state's law before you poke someone that you are in a domestic relationship with in the chest. However, you need to define domestic relationship for your state because some people consider domestic relationship as someone that you're currently living with, someone you're related to by blood, or someone who you have previously lived with. There's lots of different terminology that can be applied to that, and it's not always just your significant other. So, the states that have mandatory arrest are Alaska, Colorado, Connecticut, District of Columbia, Iowa, Kansas, as he just said, Louisiana, Maine, Mississippi, Nevada, New Jersey, New York. Now, New York has a little different. An officer may arrest a person if there's probable cause to believe they committed the offense, but they shall arrest them when they've committed a felony against someone of the same household. So some of these states have things that are a little more specific. Ohio, Oregon, Rhode Island, South Carolina has a mandatory arrest when there's physical injury. If not, then it's up to the officer's discretion. South Dakota, Utah, Washington, and Wisconsin. The next group decided to get a little more in-depth in their lawmaking. They mostly require probable cause, and in Arkansas, it's the preferred action. In California, arrest is encouraged where there's probable cause, and it's mandatory when claiming a violation of domestic violence protective order. I thought that would be, yeah. Massachusetts, arrest is preferred, but mandatory when there is probable cause to believe the person has violated the protective order. Montana, arrest is preferred when there is probable cause. It is mandatory when there is use of a weapon or violation of a restraining order. North Dakota, probable cause is required when the person is committing domestic violence. Tennessee, arrest is the preferred response. Mutual arrest is discretionary. So it's up to the officer's discretion in these other states, Alabama, Arizona, Delaware, Florida. Most people believe in Florida that arrest is mandatory because generally that's what happened. But the law actually reads the officer may arrest whenever the officer determines upon probable cause that an act of domestic violence has been committed. Mutual accusations must be evaluated separately, and mutual arrests are strongly discouraged. The policy of determination is of the primary aggressor. I thought that was a little interesting. Georgia, Hawaii, Idaho, Illinois, Indiana, Kentucky, Michigan, Minnesota, Missouri, Nebraska, New Hampshire, North Carolina, Oklahoma, Pennsylvania, Texas, Vermont, Virginia, West Virginia, and Wyoming. So if you live in one of those states and you have questions about what's going on, do a quick Google and it'll tell you the law in your state.
Okay, so that's kind of why they had to do that. And that's why we have these hearings today, so that in review, we can then make an appropriate order. And so we're going to lift a no contact order today. Two, you can have as much contact as you want. Mr. Taylor, I think you owe Ms. Rivera possibly a thank you based on what I read, and good luck to both of you. Okay.
All right. Thank you, sir.
You're welcome. You can stay or go. This is a public hearing. It's up to you.
Okay. Thank you.
All right. Have a nice day.
Thank you.
Okay. Next, we have a little different circumstance. This would be State of Kansas versus Tyler Parker, unfiled criminal case, 23 MR 292. Mr. Rutherford appears for the state, and Tyler Parker's here. And I believe I'm looking at a ceiling, but I know now I'm looking at this could be Mr. Clayton Hullett. Is it pronounced Hullett?
Yes, Your Honor.
All right. Mr. Hullett, do you have any objection lifting no contact order between you and Mr. Parker?
No.
Okay. Mr. Rutherford.
Well, Your Honor, I'm sure you read the affidavit, and
I
it
did.
seems, at least concerning the domestic battery with Mr. Parker, that this may have been somewhat mutual physical altercation. I believe, and Mr. Hullett can correct me if I'm wrong, that he was also arrested on charges.
So I don't know the relationship between these two, but say, for example, they were brothers and they got into a fight in the backyard. Brothers do that all the time, especially when they're teenagers, early 20s, whatever. If somebody calls the cops, even if neither of them want to press charges, neither of them want to go to jail, if they're in one of those states that's listed as a mandatory arrest, one of them is going to jail no matter what. So when things like that happen, you need to evaluate the situation. Is this something that happens all the time? It's not really a big deal. They're going to shake hands and be okay in 5 minutes. Think about that before you call the cops on little situations like that, but make sure you are calling the cops when it's like something important and vital and, really needs to be handled.
That evening, I don't know if the no contact order has been lifted in that case or not. There might be reciprocal ones, but if both parties at this time want this one lifted, I have no objection. But for Mr. Hullett's information, if that still is in place, he's going to need to get that lifted too.
Mr. Hullett, do you know what the status is of your no contact order?
I called the state, or I called somebody, and I had them try to lift it, and they told me that I had this court hearing. So I'm here today on trying to get this no contact order lifted, just so I can see my brother again.
So Mr. Parker is your brother?
Yeah, we're non-biological brother, Your Honor. I've helped him through some really hardships.
Okay.
So,
You mean brother in the close friend situation. Okay. All right.
correct.
Okay. Well, what Mr. Rutherford pointed out is, Mr. Hullett, you were also arrested
Correct, Your
in
Honor.
this incident, and you have to file a separate request to lift that order,
Okay.
and you haven't done that. So
Okay.
we're going to lift it as to Mr. Parker, but the two of you still can't have any contact.
Okay. I will
You've got to
get.
you have to come to the court and file a written request.
Okay. I can do that today, Your Honor.
Okay. Now, Mr. Rutherford, do we want to have to reschedule him for a hearing? If he comes and files an order, do you have any objection to me lifting it if he actually shows up and does it?
No, Your Honor, that'd be fine.
Mr. Hullett, if you come to the court and you file the paperwork, they'll give me an order and I'll lift it at that time. But until that time, the order's still in effect. Understood?
Understood, Your Honor.
All right. So it's up to you to get here and get that filed. Now,
Sorry to keep interrupting, to keep making important points that we don't usually talk about or think about. When there's a mutual arrest for domestic violence, there are mutual restraining orders put in place, and you can't just get one lifted. You have to get both of them lifted on both sides in order to resume contact with that other person.
Mr. Parker, I read the affidavit. There may be some far more serious charges against you arising out of this incident that occurred at the residence, from my reading of the affidavit. So I don't want you to get any misconception that somehow this whole thing is blown over and is gone. It can be far from that, okay? And that's up to the county attorney's office whether they file or not. But I can tell you that from what I read, if they file, you could be looking at least one, if not more, felonies. So you may want to contact the county attorney's office and visit with them. But as to Mr. Hullett, you can have contact with him. He can't have contact with you. And as soon as he files his motion, the two of you can have contact. Understood?
Yes, Your Honor.
All right. Mr. Rutherford, anything further from the state?
No, Your Honor.
All right. With that, we'll be adjourned, gentlemen.
I got one question, Your Honor.
Sure.
So the domestic battery that is against me, that's being dropped, correct?
No. We're dropping the condition of bond that you can't have contact with Mr. Parker.
Okay. So we
Just
still have
Mr.
court.
Parker's
then.
potential domestic battery charge against you is not dropped either. It just means that is a bond condition as part of your arrest. That's being lifted.
Okay.
But-
So,
Charges could still be filed. That's up to the county attorney's office.
okay, so. Okay.
Okay.
Your Honor, I have a question too.
Sure.
I filed the motion so I can try to get this no contact order. That's why I have this paper right here for everything for this court hearing today.
Yeah.
Okay, I just wanted to verify that.
And I lifted it.
Okay, I appreciate
But-
that.
But Mr. Hullett has a no contact with you from his arrest, and he did not file the paperwork, and that order is still in effect. If he comes to the courthouse today and files the paperwork, I'll lift it based on the conversation today. But until he does that, it's still in effect.
Okay, I got you.
But it's not as to you. You can contact Mr. Hullett, but if he contacts you and the police find out, they could arrest Mr. Hullett because he still has an order.
Okay, that makes sense.
Okay, very good. But if he gets up here to the courthouse and gets the motion filed, it'll be taken care of today.
Okay, thank you, Your Honor.
But like I said, that doesn't mean that there's going to be no criminal charges out of this.
Yeah,
Okay? The county attorney can still file a criminal charge. This just lifts the no contact condition of the bond.
okay.
Okay, very good. Good luck to both of you.